and send the final order, approval order, saying, and I recognize it's probably, unenforceable, but there was a loophole. Where in this Amazon cases, the ones that went up to the Supreme Court, the court said, well, we're resolving this, and FAA managed arbitration no longer enforceable in independent contractor contracts unless it only deals with the last mile delivery. That's an industry term for super local, because federal government can only worry about interstate commerce. So we might want to hear something on an intrastate case down the road. You guys said, well, this could be intrastate. Give them a fighting chance. We're leaving it in. But I agree with you guys. I can't bind everybody in the contracts automatically. We have to give them a chance to sign, so that they knowingly, willingly know. Just taking the money doesn't automatically bind you to it. You have to also sign the deal. Sounds great. Everybody wins. Everybody gets what they want. Our primary problem was you can't automatically bind people to a crappy new contract. Just, okay, we're going to make sure everybody has to sign. Just taking the money isn't enough. What does, automatically deducting have to do with wage claims? Nothing. Why do we even need a new contract? We really don't. But at least now people have the option to sign, and we felt that was a win. They also said, but since you interfered with the process before, or accused of it, if you guys disparaged the settlement, if you tried to dissuade distributors from automatically signing so they can get a pittance to give up constitutional right, or at least to have to fight for it, spend money. So, in the end, the third settlement agreement had in there the signing requirement. And we felt like that was as far as we could go without blowing the whole thing up for a few more years. And the formers who, the new contract didn't matter to them. Like part of the pre-certification, this was genius on their part. Oh, we're going to have a class list that includes former people who care, what not, if they have to be bound to a new contract because they're not in the business anymore. And then the other part of them are current who now would be bound to this new contract. And they would keep making arguments to the court. Oh, come on, Judge. More than half the people in the class list don't care about the new contract. Yeah, because they're formers. What percentage are former and which are current? We never got that. We had to reverse engineer. We could never get a copy of the list. They hide information. We know they are representing the facts. Hal Jordan signed a declaration that was demonstrably false. You don't just charge back people who sign side agreements, you charge everybody back, whenever you want. So that's where we were with the settlement, and we stopped objecting. We promised we would stop objecting if they would give everybody a chance to sign. But then they, typical fashion, said, okay, well, before we send you the check, first you got to electronically sign. We're back to that again. And it was too late because we had already agreed to the settlement and the final approval order already went through. It was still the best deal we could get. Now, there's a whole bunch of present legal actions going on. I'm just going to leave this side up here for a second. If you see a cause of action, retaliation and wrongful termination, and personal injury action, but we really aren't in a position to comment on ongoing litigation because it could create a distraction. We all know too well on the legal committee, you give Pepper's Farm an opportunity to rack up somebody's legal bill and say, oh, there's an ongoing litigation, and they were talking about it at the convention. So we're not going to talk about any of the specifics of these cases. It's a shame because one of our board members was from Texas, wasn't affected by this buyback. You guys are aware they bought back routes in was San Antonio, Arizona, St. Louis, Missouri, right? So can't really get into that. But these are the kind of causes of actions we need the Legal Shield people to be aware of. This is what's been going on all over the country. Just ongoing right now, as far as we know. There may be more. Like we have our law firm on a tickler, and that takes money, which we're going to talk about later. Let us know when something enters the dockets of any court so we can take a look and see what kind of lawsuits are going on. Then we'll go, look, if it looks like something important, we'll pull the records, read them, and then we'll report about them. Future legal actions. This is like a tough one. Pepper's Farm knows they're in breach of contract, and they're doing it anyway. Campbell Soup knows they're in breach of contract, and they're doing it anyway. Because, one of the things we preach about on road shows and we do workshops out in the field around the country, litigation is a really lousy business strategy for a small business because, you know what? It's really expensive. Lawyers, you pay them hundreds of dollars an hour. And it takes hundreds of hours to do a couple little things. And ka-ching, ka-ching, ka-ching. Hiring a lawyer adds up really fast. Say, oh, let's do future legal actions. $50 membership donations or $200 member donations will get us a couple hours. Even if everybody contributed, it doesn't get you anywhere. And here's the thing, and I know we're like, oh, I'm so mad at the plaintiffs' counsel in Connecticut, in Illinois, Massachusetts, and California, and Ohio. And I'm really kind of disappointed in the Pennsylvania people because there were just motions filed in there and they were pretty lousy, in my opinion. But it takes a lot of money. So to say, oh, as an association, let's pull all our resources and sue. I'm not sure if that's exactly the right answer. That's something that needs to be discussed. This is meant to spark discussions on this issue because pallet fees. I know at the post-2001s there's a side agreement that some people with the really lousy blues and under the new contracts in the 3 states and in Connecticut, they can do it. But we're DSD. Pallet deliveries are for their central warehouse side of their business. Every existing contract, even the new ones, have in paragraph 9, bakery and the consignee shall use their best efforts to promote DSD over district and central warehouse distribution. We're supposed to be the first line of sales, and then you do central warehouse. Then you do e-commerce after. Right? Delivering pallets directly into our accounts is disruptive. I don't know about you guys. And I know some people like them, like in rural areas. We've done a bunch of Zoom calls and workshops. Oh, yeah. Geez, they're sending pallets to my Walmart. That's a 40-minute drive, an anomaly outlier on the edge of my territory. Saves me in gas, I'll pay the 5%. But the 5% in pallet fees adds up to hundreds of millions of dollars. And they're using it to subsidize trade spend like they are with the nonsensical trade promotion without trade spend. It's like it's a made-up term. The thing we talk about in the newsletter a lot. Control the language, you control the thought. Where in your contract does it say max cap? Pepper's Farm reserves the right, and its sole discretion, to impose max caps on your weekly DSD orders so they can sell to e-commerce and central warehouse. If you don't have enough ingredients to make enough of this stuff, it comes to us first. Right? Oh, well, you're captive. 1 case of this and 1 case of that. Oh, by the way, you can get 2 cases for the price of 1. We're doing a BOGO on our Amazon web store. We're competing against our exclusive supplier. Who signed up for that? Anybody? I mean, we did. Anyway, there's some really juicy ones here. Right? Breach of contract. That's what they want. There's this doctrine called just in case. So even if they malicious breach of contract, go ahead and sue us, and we'll outspend you. Right? Go ahead and sue us on breach of contract. You're going to spend $1 million to prove I ripped you off for $100,000. What kind of business person are you? It doesn't make sense, and they know it. But there is no such thing. If you look in the law books, you talk to the legal shield guy. We can't find something called malicious breach of contract. There is no such thing. The legislature, all right, it's breach of contract or it's not. Okay, look can we all join together and do a class action for breach of contract? Well, no, because every contract stands on its own. So breach of contract is, even though I have the exact same contract as Gary L, okay, they're two separate contracts. They're two separate parties. You can't say, part of the reason they've surreptitiously introduced all these different variations in new contracts is to muddy the waters. They say, come on, there's the yellow, there's the green, there's the blue. Now they stop changing the color. There's the blue version 1, the blue version 2, the blue version 3. Now there's the, green diluted, the yellow diluted, because now the new contracts where people sign, they've got a dozen different contracts. How can you bring a class when there's no commonality? Because one of the themes of getting certified as a class is there's a common issue, a common thread to everybody. So we say to the class action, yeah, well, it's like an insurance contract or like a telephone one where it's like boilerplate, it's the exact same provision. Every Comcast customer has the exact same boilerplate contract. The courts will allow sometimes those sort of breach of contract actions, but the old timers here will remember, spent $750 million on the Davey lawsuit trying to bring a class breach of contract, and we lost. In motions. $750,000 to find out. Yeah, every contract stands on its own, and you have to bring them as individual causes of action. Pepper Farm knows that. Go ahead and sue us for breach of contract. They welcome that. They can drag it out and use their deep pockets and never have to address the merits of the case, just like they did with us on the objections. It's crazy. Technology fees. John Teets gave a talk last year. He's going to give an update this year. It's an important issue. Where in your contract does it say you have to buy your truck from the Campbell Soup Snacks truck dealership, and you can only put gas from our approved vendor? Right? It doesn't. It says you have an obligation to get the right equipment to run your independent business. You're independent. But now I gotta buy a new computer and a new printer and a new gimme key, and I can only get it from you or your partners, my exclusive. Okay. Well, I want to bring my own device and do it myself. Well, still owe us $20. Yesterday, they sent out the email saying, oh yeah, the $20 for the do-it-yourself, for everybody that's asking, the 20% around people that are asking, is, yeah, it's to pay for the software that we bought. Where does it say in the contract you got to pay them to subsidize their technology infrastructure upgrade? You bought new software? Great. You used to use it? Great. Charging me for it? Whoa, whoa, whoa. I didn't get to pick it. Right? I'll mail my tickets in. I'll handwrite them like we did in the old days. Right? Why are we paying you to help you make money? Those technology costs are yours. And we were arguing this before at Operation Impact too. The whole idea of having, we talked about it last year, I'll do it again a little bit in my other talk, but tech's gotten so advanced, so fast, right? We totally get you need to upgrade your technology infrastructure. But the trend for the last 15 years has been device independence. The open source community, we're going to talk about later today, crushed Microsoft. Bunch of volunteers working together, right? So, having the right code to run on, a 32-bit Microsoft Windows machine, or 64-bit, compiling code down to target specific chips, that's like, 10 years ago. It's device independent. The internet, ubiquitous connectivity, you can access applications out of the cloud. And it doesn't matter if you use Apple, and you use Android, and you use something else. I don't care. If you can access the internet, you have a modern browser capability, you can run applications on any device. Android, open source operating system, has a common Unix print system, cups built into it, handles thousands of wired and wireless prints built into the operating system. But you can only use the new Zebra one, you have to buy it from our supplier in the little crappy rolls of paper, can only buy the paper from us. It's a way to generate revenue and shift costs over to the distributors. And it's a problem. We've been complaining like crazy, and encouraging everybody to complain. This representation and fraud. Kyle Jordan filed a declaration with the court saying, we only ever charge back pursuant to a duly signed agreement. Not true. Right? We've gotten more untrue statements in writing from them than you can shake a stick at. And it's kind of sad. He purposely mislead, half-truths. You guys read the newsletter, right? Half the truth is just as bad, if not more insidious, than outright lie. Price discrimination, the bulletin price list. Why don't they have, like, I love this, new guy. Why is bulletin prices a defined term in your contract? Because that's how you calculate consignment commissions. What's more important to a consignment sales business than a term that's expressly defined? Make no mistake, this is exactly what it means, because it has to do with how you earn. Not a salary, you earn a commission, sales commission. How do you do that? Oh, bulletin prices. Why is it defined? Oh, because there's a list of consigned products, Schedule B. That's the only place in the kind you will earn at a rate of 20% of the published bulletin prices. Okay, great. They stopped publishing the bulletin price lists. How can you verify that you're getting paid the right amount? How do you know? You don't have the list. The whole bulk mania thing. In June, we'll get a letter. You'll see. It's been happening since 2015. So happy to announce a new VIP, blah, blah, razzle, dazzle, rah, 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 with Walmart. Huh? Yep. And we're going to pay you the wholesale prices reflected on your invoice. What? Well, where's the price list? Because without the bulletin price list, how do I know the price on the invoice is accurate? How do I know you're not skimming 5% from my commissions by reducing the wholesale price on the invoice and paying me off of invoice instead of what you promised? 20% of the bulletin price. Oh, it's a trade promotion without trade spend test. Purposely misleading. Happens to also be a violation of the Robinson-Patton Act. Under the antitrust law, it says, big, gigantic companies, right, manufacturers, you're not allowed to discriminate on pricing. You can't pick who wins and loses in the marketplace. I can't say, Gary Eller, I'm going to sell you this for $10 wholesale. You can tell you get it for 50 cents. You get more. Who's going to do better? Have more sales? You got the lower price. Can't do that. It lets you pick the winners and the losers in the marketplace. You can't have price discrimination. Under Robinson-Patton Act, it says all similarly situated retailers have to get the exact same retail price. But how are you going to know if that's really happening? How do you enforce compliance? How do you enforce accountability? Oh, you look at the price list. There's one price for each skid. You know, bag of goldfish, wholesales, $1, whatever. You know, and everybody that's a link in the supply chain knows we're all on the same page because, oh, published prices. They have the published list. We're all working from the same page. When I work, get it out of your handle. I can't. Right? Use your handheld. Nobody brought their hand up today. Print me a price list from 4 days ago. What was the price of goldfish 4 days ago? Use your handheld to do it. You can't. Impossible. Why are they hiding the price list? And why are they paying us off an invoice? Because we're subsidizing the new tech upgrade, the new tech infrastructure that allows them to manipulate prices with that sort of granularity. The fact that you can change prices from millisecond to millisecond doesn't mean we intended to allow you to do that. There's a notice provision in every contract. Notices that shall be given in writing prior to whatever you're doing. The one thing that the integration clause that everybody's got to sign before you can change anything, the one thing that doesn't apply to is the list of consigned products, Schedule B, where you get paid. The one part of the contract that says, this is how you're going to get paid. It says, oh, well, we can unilaterally change the wholesale prices to whatever we want, whenever we want. Okay? Totally get that. We agree with that. You guys make the stuff, you set the price. And the four pricing is efficacy, that's kind of questionable. You can set the prices you want, but you got to give us prior notice. And you got to do it through the bulletin price list. So everybody's on the same page, literally. And they stop doing that. That's a problem. Shareholder action. Gary Eller. I'm really looking forward to this one. You know, instead of spending $1 million on lawyers again to lose it before you ever even get to present your substantive argument, what if we had $1 million worth of stock? And we had a proxy voting capability and showed up at shareholders meetings and said, hey, this new management team's screwing around with the distributors. We're shareholders and distributors. We want you to fix the policy where you're ripping us off and at least have it out there. You know, probably not enough votes to carry the day, but enough votes to put it on the radar of the analysts and call out this company for ripping us off. Oops. Question? Jack, you want to add anything?
I think I'm just concerned that the clarity in what Jody was saying, maybe some people didn't understand. and how it's not whether the question isn't whether you're getting paid and your commissions are calculated at 20%. It's what the 20% of. And does everybody understand that? So what's 20% of $1 and what's 20% of $2? Well, they can change that dollar amount. It doesn't matter if you're getting paid 20%. This is the number that they can make up. So think about when they changed the price in Walmart for the bulk goldfish. On one day, I can go out and serve 4 chain accounts, one being Walmart, and I made a different commission. I made different profit on the same SKU based on the chain I sold it to. And that's a problem. I want everybody to realize that they pulled the prices the whole business. How you calculate your commission based on a percentage of 20%, the rate 20% of what number. And that's why if you've been around for a long time, you didn't have to both sign. It was a fluid document that came when